So we're back on the Gregory Martin Sr. matter. We left off with cross-examination finishing of Mr. Waleed. Mr. Waleed, now is your opportunity to do what we call redirect, which basically means you get to respond and clarify any answers you gave with respect to cross-examination. It's not a time to introduce new evidence, It's a time to respond to things that were asked of you. So you're still under oath, go ahead.
Okay. We want to jump right into the Oregon State Bar. We're talking about the durable power of attorney, and it's called the powers of attorney and other decision-making tools. That is on the Oregon State Bar, and it mentions specifically a durable power of attorney. I like to just, it's a real small paragraph. I just want to put it on the record. A power of attorney generally become effective when you sign the document. Oregon law also specifically allows powers of attorney to take effect at the time other than when signed. You can give a specific date when it will go into effect. You can list a particular event that would cause the power to be effective or describe a situation when the power could be used. This type of power of attorney is called springing power because it springs to life only if the event outlined in the document comes to pass. If you prefer to give an agent power in the future, if you become unable to handle your affairs due to incapacity, you can also say who will determine if you have become incapacitated, such as one or more doctors or the court. This was downloaded October the 22nd, and it's still up there. It's been up there for, several years. But when my sister showed up, and when Earl and Selena had powers of attorney, I never had a power of attorney with my father. I knew what was signed when he became sick. In our durable power of attorney, it states that I'm to take over his affairs, and it mentions open bank accounts. It mentions all of the different things that I have the privilege for my father. And I believe one real reason for that, my father don't like to be controlled by nobody. He makes his own decisions about a lot of different things. That's just my father. He's the elder, and being his son, I could have started some stuff back in 2019, but I'm very careful with my father not to impose certain things on my father. Like if he's incapacitated and he thinks there's certain things happening, he just already has a non-trust for everybody. That's just how my father is. He's been that way his whole life. He's been, stolen from, stuff taken from him, tools, materials, the city of Portland, $500,000 in liens on one property that we're dealing with now. So my father just has a total trust thing according to all my sisters. That's who my dad is. You can't change what happened to him as he grew up or evolved in his experiences with people and businesses. He's like that. He's never ever told me, son, I don't trust you. My dad relies on me because I'm the one who learned the trade, electrical contractor thing. So I just wanted that to be known. It's called the powers of attorney and other decision-making tools. It's on the Oregon State Bar website, but it specifically talks about an event, and this event happened. And I was just not able to, with the Adult Protective Services, we haven't seen any doctor, anything other than the several people who've been in this ex-parte communication. They're saying stuff, but nothing's been submitted to the court. I'm just concerned in this, why one of the doctors that they talked about has never come to the court, similar to Mr. Steenson, a professional who, is third party. So that's just about that durable power of attorney. Now, there were lawyers that were really good friends in the union. I've got some pictures of them here. There's two of them here. I used to go see my uncle on certain job sites, but I believe this guy is Cliff right here, and this is Hank. These were two attorneys. My uncle was the president of, and the business manager of Local 296. Everybody went to my uncle for different things, and he was fortunate. He was a good business planner, but he made me and my father type up the document. But me and my dad didn't know what to do as far as how to follow the rules other than what Uncle Nathan told us both to do with him being the pledge holder, that you need, Junior, you need to keep records with your father because your father missed some stuff, and he told my father, you need some help. You need your son to work for you. Because when you get older, you're not going to have any money. And that was the story. My dad was just so interested. I get to work this little mother? His attitude. I get to work him? And so my dad was all in. And he's still in. He's just lost his mental capacity. And if I didn't have those documents and didn't have proof of all of my labor working for my father, then I'd be in a different state of the situation. I wouldn't have a leg to stand on. But one thing that I do well is I document stuff. And so I just go in a little bit more because I know what my interest was, but I never thought it was going to happen like this. Like my father would get incapacitated and he couldn't follow through. But looking at the research now, I see the people took advantage of him, everybody. That's why there's not one property in his name right now. And that's what I'm here to fight and to change. And I've watched the actions of different people. I've seen the ex-party communications. It's wrong. It's unethical. So we'll let the other parties do this. I just want to get to, I can't make up a lie about, well, this lawyer did that and that didn't lawyer did that. My Uncle Nathan was the head of the family. So we all went to Uncle about different things, and he's the only one that could talk to my father, especially him and Uncle Ed, when my father might have said some things he shouldn't have said to me as a youth. I know my uncles would, hey, you better watch that with Junior. Don't tell Junior that. Don't get no attitude. And he'll laugh it off and grin it. But these were his older brothers, so he had a lot of respect for Uncle Nathan. Uncle Nathan was just a very important person, but he died in 1995. And so our whole thing with me and my father was keeping the agreement and following through, as long as I have the documentation. But my father kept all these years. He never had sold any of this property. That was the deal. He never had what we call we talked about it today, he never had a will. Because this is what the will was about. And my sisters, they never had claim. He was never going to just give you anything. You got to earn it from my father. That's my dad. You don't earn nothing, you're not even a thought. So these issues are important. The relationship about Oregon Advocates LLC, yes, I had lunch with them. I would really wondered what they wanted to see, but fortunately for me, I had already purchased my father some clothes because I was told that he needed more warmer stuff. I bought him some stuff at Veterans, spent several, $300-400 on, but it was too light. It was pajamas and stuff, and he needed some coats, he needed some sweatpants, he needed, some hats, so that way where he's at the Avalon Care, he's been out in his wheelchair, he knows how to move around a little bit more, he's made some friends out there. And then I don't go to my father asking him what did such and such say. I don't want to give him that confusion. He's already having a mental issue. He's going through his own moping about not being able to do things. So I don't bring that to my dad. Our deal, and that to me it speaks for itself. I've kept the excellent records over the years, and there's ledgers too that I don't know where they are. That's what I'm after. Because it has a lot of things that I was looking into for my father was about him paying bills. So when this Toya lady got this $40,000 and I found out about him 218, my dad was upset. He was, because as far as he's concerned, I'm in his business. But you didn't take care of the business that we already have, and that's paying the taxes, the houses were, not being taken care of. You heard Luca. He just became like a slumlord for a minute. And there's nothing I could do about that. My deal was to keep the businesses going as far as the work, finish the electrical work. I have a license here in Oregon, especially the times that we worked. But I was always bidding the jobs because he forgot what materials go in an apartment, what kind of switchgear. He used to know this stuff. And so I just see over time my father, like especially from 19 up, he wasn't the same person. And so, I don't live here. So I'm not in his business, but they were hiding him from him. Like I mentioned, I contacted Earl and Selena. He was telling people he didn't want to talk to none of his kids. I really believe that. I really do. Because my father can be like that. But if you go to sleep on my dad, and you don't take care of business with my father, he'll act like there was no business. So if I didn't have the documents that he signed, and if I didn't take care of business like I did, I would have a different position. So like I said, I love my father. I care for him. No, if he was not in this situation and we did what we're supposed to do naturally, he'd be in the facility that he's in right now, honestly. And I would have managed his affairs much better than anyone. And the only way to do that is to go back and, litigate in order to get his assets and his property back. But they were already pledged to me and earned by me. They're not a part of the estate. I've said that from day one. Just because he got incapacitated, people took advantage of him even more. And that's why we have Oregon advocates here and them here, because they didn't do the right thing. We could have sat down and mediate this before we went on a 7-month trial. And I was not going to stand by and just sit there and not litigate. But I've seen enough that I think Mrs. Fuller is a great person. I think she can care about my father. But I think from my experience, what I've seen, that they will lie, they will cheat, they will be in a position where it's hard to trust them when you're talking to judges and getting rulings without us even being there to object. That's a hard pill to swallow. And now that we've got the audio and the proof of all this, it's a whole nother story. So it's just it's a trust issue. And it's not just because of my father. I watch how they handled my father's affairs and what they would do to get ahead. And that's something that is unethical to me. It's unethical to the courts. It's unethical to the Commission on Judicial Fitness. It's unethical to the State Bar, who license lawyers, and it's unethical. It's in the rules. So yeah, I don't trust them. I don't want to do business with them. I don't want to leave anything with my father. They ran their course, they ran their race, and they left my father in a disposition that he shouldn't have been in. And there was other people, Luca and other folks, they didn't go out and do no research. They didn't pay to get anyone served. They didn't pay. They didn't even serve me. I'm his durable power of attorney. You can't run from that. And he was incapacitated in March, according to the story. So I'm the one that called in December to find my father. And I talked with Ms. Huffman, and she says, okay, I let her know about my durable power of attorney. I mailed her a copy, okay? She never made sure that got in front of the so-called ethics committee. Instead, they called third-party people from another county to come in, and this is what we've been dealing with. And now that we see everything, it's just not fair. And we can't just sit around and let them do what they're doing. Fortunately, there is a legal venue, and there has been some racketeering with all of them together 3 different times. So that's the issue. We didn't get to talk about Steenson, but that's something I'd like to submit in the evidence. Can I pass this around and submit this?
Well, my understanding is that you've subpoenaed Mr. Steenson, and we're going to have him back here at 1:30.
We can talk about that then.
That's the plan.
Yes. Okay.
Yeah. So I just wanted to finish with your cross, and it made sense
Yes,
since you had something. And
I just wanted to note this.
what,
I think
what,
this.
what is that?
It's the Oregon State Bar. It's their power of attorney tools that they have up there that's on the website. It's been there for a
You
few
want to
years.
submit that as an exhibit?
Yes, I would like to. It's
Okay.
it's something
You
that
showed
all the
that to
lawyers.
the
Yeah,
judge,
you can go look at that.
What, L? Okay, we're up to exhibit N as in Nancy.
Thirsty.
No objection, Your Honor.
Okay.
No objection, Your Honor. I would point out that this is an article published on the Oregon State Bar's website. It's not a statement of the law. Chapter 127 is the law on powers of attorney.
Okay, but no objection.
No objection.
All right, so Ms. Wilkes, did you have any objection to this coming into evidence?
No objections, Your Honor.
All right, we'll go ahead and receive it. Then it's marked as OW for objector Waleed, N is in Nancy. Okay, Mr. Waleed, sounded like you were done with your.
Just one thing, just to add to that. This has been a, I won't say unnecessary process, because to me, what was uncovered, I just think we got to the bottom of it, about some issues. I don't believe what Mr. Rudolph is stated about my father. All we have is several times he spoke to my father. My father never spoke to him, so if he just said something different, it's new. But I'm not gonna go question my father and say, did you speak to a guy? Because I don't need that. My father doesn't need the stress. He needs to be in his state of healing, that he's in a place, a facility where he can sustain himself, he can get better, he can meet some friends, et cetera, versus bringing him into the court again when he's not here to say what Mr. Rudolph said about what my father said. It's hearsay. So, and under the issues and the complaints that I filed, anybody can say anything, but the facts speak to themselves. That and the court is witnessing things and can see it, that we got people that aren't paying fair, and that's what ex-parte communication should be about. It's unethical, and I feel we missed 3 different occasions to object, and we didn't even get notified by Salisbury, Rudolph, Fuller. No one told us, even the court visitor. And hopefully Mr. Steenson, and if he's going to be able to testify, he'll be able to state why this letter was written, about all the different things as far as the court visitor lying about on her report, Fuller being unsuitable this year, and as well as Salisbury and Bungie getting contacted by Mr. Steenson, and they never responded back or checked the record. My concern with Mr. Steenson that we're talking about is really, why was he running from the subpoena? And he does have knowledge and facts, because he sent it to the court, to Judge Henry, about the issue. And why would he say he doesn't have personal knowledge when he wrote a 4-page
So we're going to
article?
get to that after
Okay.
lunch. Just wanted to get
That's it. That's all I got to say.
All right,
for the
thank you,
record.
Mr. Willie.
Thank
so, we'll. Do we have any other
No, nothing else.
hearing matters that we need to address? If not, we're going to adjourn until 1:30. But Mr. Stenson is scheduled to be back. Mr. Rudolph.
Your Honor, I wasn't clear on the admissibility of, I think it was OWK, the durable power of attorney document that I believe you were going to conditionally review over objection. I just wanted to be clear as to whether that was admissible.
My recollection is that there was OWK contains just several pages, and it became rather inefficient use of time for everybody to go through and redact what is not admissible in the evidence code and what is. beauty of this is not a jury trial, it's a court trial. And so I believe what I said is, if I didn't say it, I'm saying it now, OW for objector will lead, K as in King, is conditionally admitted to the extent that the court will only consider what is allowed under the evidence code. To the extent that it contains information that's not allowed under the evidence code, the court will not consider it. I believe that's what I stated last time, and that's what I'm just repeating today.
Okay, understood. Thank you.
Can I add something to that, or
Yes,
ask
go ahead.
the court question? What I believe to be the evidence rule that we wrote is to be admissible, it has to be able to change a particular fact or answer a fact that will be proven, so that way it is admissible. What is the condition of it being admissible is my question.
Well, it depends upon what it is that's in there. Again, it's several pages. I think what
Okay.
Ms. Rudolph is referring to is whether or not it's hearsay.
Oh,
I think what you're referring to is whether or not it's relevant to the case.
yes,
Whether it has any
it's
probative
relevant.
value. Two different legal issues, of which
Okay.
both of them are contained within the evidence code. And so to the extent that anything in that exhibit comports with the evidence code, then it will be considered.
Okay.
So, for example, the last piece of it, which is, I think, entitled the Martin Durable Power of Attorney, we
Yeah.
spent quite a bit of time discussing. In the court's opinion, it is not considered hearsay, that particular piece of that exhibit. There are other things I just haven't got to yet, but that particular piece would not be considered hearsay because it's a contract, it's a document that has an independent legal effect under the evidence code. So if any party wants to place an objection on the record with respect to that for purposes of appeal, now is due time.
You know, I'm going to object on lack of foundation, lack of authentication, and the fact that I don't believe this is an original document that's been submitted to the court. So under the best evidence rule. So for the purposes of the record, I'm making those objections.
Okay, thank you. Mr. or Ms. Salzberg.
Not making any independent objections, I concur with.
I have an
Mr.
objection.
Well, you've asked me to admit it. Why
Oh,
would you be
okay, gotcha, I understand.
With respect to just the Martin
Durable
power of attorney piece of Exhibit K,
Gotcha.
I've explained why I believe it's admissible, why I'm accepting it.
Okay.
And they've placed their objections on the record for purposes of an appeal.
Okay.
They've preserved that issue. And so, Ms. Wilkes, did you have anything you wanted to say?
No
on that piece?
objections, Your Honor. It should be admitted.
All right, thank you all then. We're going to be adjourned until 1:30, and we'll resume with Mr. Stenson at that time. Thank you.
Thank you.